Okay, trigger warning for this next story. This is going to be about actions taken against transgender people. And I don't want you to have a bad day if this is something that bothers you on an emotional level. It bothers me on an emotional level too, and that's why I want to bring it to you so that we can go over what's happening in Texas. On February 22nd, Governor Greg Abbott, apparently in response to a failed law, instead issued an executive order basically ordering the Department of Family and Protective Services to treat transgender children as having been the victim of child abuse. In other words, notwithstanding any actual child abuse, if a family, parents, doctors, counselors support a child's gender issues, that's child abuse, according to Texas. The Office of the Attorney General has confirmed that a number of so-called sex change procedures constitute child abuse under Texas law. The Texas Department of Family and Protective Services, DFPS, is responsible for protecting children from abuse. So the governor, Greg Abbott, hereby directs your agency, the DFPS, to conduct a prompt and thorough investigation of any reported instances of these abusive procedures in the state of Texas. The Office of Attorney General Opinion Number KP0401 makes clear that it is already against the law to subject Texas children to a wide variety of elective procedures for gender transitioning, including reassignment surgeries that can cause sterilization, mastectomies, removals of healthy body parts, and administration of puberty-blocking drugs or supraphysiologic doses of testosterone or estrogen. These are things that would normally be between the child and the family and the doctor, and now Texas is inserting itself into these medical decisions. Texas law imposes reporting requirements upon all licensed professionals who have direct contact with children who may be subject to such abuse, including doctors, nurses, teachers, and provides criminal penalties for failing to report such child abuse. So they've gone from investigate because it could be child abuse to now just flat out calling it child abuse in this second paragraph. There are similar reporting requirements and criminal penalties for members of the general public. Texas law also imposes a duty on DFPS to investigate the parents of a child who is subjected to these abusive gender transitioning procedures. So again, we've gone from it could be child abuse to it is child abuse to it's abusive. It's just taken 3 paragraphs to just transition from the potential for child abuse to now it is definitely abusive to even think about it. And on other state agencies to investigate licensed facilities where such procedures may occur. To protect Texas children from abuse, DFPS and all other state agencies must follow the law as explained in the opinion. Now, why would you institute an executive order? Because it's easier than changing the written law. So I'm assuming that because he's issued an executive order, the law actually doesn't say this, and the ACLU agrees. On March 1st, the ACLU sued on behalf of one of the first victims of this law. These plaintiffs are maintaining their anonymity as John Doe, Jane Doe, and Mary Doe, the child, as well as their doctor, Dr. Megan Mooney. The ACLU and Lambda Legal have asserted basically that these laws are illegal, and they've asked for a temporary restraining order, temporary and permanent injunction against Greg Abbott, the DFPS, etc., against enforcing these laws. I'm going to cover just a small part of this because this is a 68-page complaint, and then we'll go over what has happened afterwards, which is the not an ending, but it's a happy non-ending, and we'll go over that in a moment. After Texas failed to pass legislation criminalizing well-established and medically necessary treatment for adolescents with gender dysphoria, the Texas Governor, Attorney General, and Commissioner of the Department of Family and Protective Services attempted to legislate by press release. Governor Abbott's letter instructed DFPS to investigate the families of transgender children, which is entirely without constitutional or statutory authority, and despite this, the commissioner nonetheless issued a statement directing DFPS to carry out the governor's wishes and agreeing to follow a non-binding legal opinion that did not change Texas law. The governor has circumvented the will of the legislature, and in doing so, he and the commissioner have run afoul of numerous constitutional and statutory limits on their power. When an executive goes outside of their power, we call that ultra vires in Latin. You might see that term coming up. The defendants have, without constitutional authority, acted to create a new definition of child abuse that singles out a subset of loving parents for scrutiny, investigation, and potential family separation. Their actions caused terror and anxiety among transgender youth and their families across the Lone Star State, and singled out transgender youth and their families for discrimination and harassment. What is more, the governor's, attorney general's, and commission's actions threaten to endanger the health and well-being of transgender youth in Texas by depriving them of medically necessary care while communicating that transgender people and their families are not welcome in Texas. The governor has also declared that teachers, doctors, and general public are all required, on pain of criminal penalty, to report to DFPS any person who provides or is suspected of providing medical treatment for gender dysphoria, a recognized condition with well-established treatment protocols. And DFPS has started investigating families for child abuse based on reports that the families have followed doctor-recommended treatments for their adolescent children. The actions of the governor, the commissioner, and DFPS violate the Texas Administrative Procedure Act, are ultra vires, and therefore invalid, violate the separation of powers guaranteed by the Texas Constitution, and violate equality and due process protections guaranteed by the Texas Constitution. Plaintiffs ask the court to enjoin these violations of Texas law and of plaintiffs' rights and immediately return to the status quo ante, the status before this was implemented. So the plaintiffs are John Doe, Jane Doe, and Mary Doe, residents of Texas. Mary Doe has been diagnosed with gender dysphoria. She is transgender. It is a serious medical condition, and she is currently receiving medically necessary care for the treatment of her gender dysphoria. Megan Mooney is a clinical psychologist and mandated reporter under Texas law. She is based in Houston, and she has a practice that includes many transgender patients who have been diagnosed with gender dysphoria and are receiving treatment. The ACLU goes through how treatment for gender dysphoria is well established and medically necessary. This is not some unestablished or unsupported treatment. From a very young age, Mary Doe has expressed herself and behaved in a manner that does not conform with the stereotypes associated with the sex or gender she was designated at birth. Her parents have been supportive and accepting of her, giving her the space to express herself and explore who she is. She has been under the care of the same pediatrician most of her life. Her pediatrician diagnosed her with gender dysphoria and referred the family to other medical professionals who likewise confirmed that Mary suffers from gender dysphoria. The family has done research to educate themselves about gender dysphoria and its treatment, and connected Mary with youth support groups that would permit them to have discussions as a family. Following Mary's diagnosis, Mary's doctors recommended that she be provided with medical care to treat and alleviate her gender dysphoria. This care has included the prescription of puberty-delaying medication and hormone therapy to initiate puberty consistent with her female gender. In consultation with these doctors and after extensive discussions about the benefits and potential side effects of this treatment, the family jointly decided to initiate treatment for Mary's gender dysphoria. This treatment has been prescribed by Mary's doctors in accordance with best medical practices and what the family understands will be the best course of action to protect her physical and mental health. And then we have a cat who would very much like to get out of the room. As you can see, she is staring at the door. And she is very upset that I'm holding her. Go ahead, hon. Mary was worried about having to undergo a puberty that would result in permanent physical characteristics not in alignment with her female gender. Being able to be affirmed as who she is, including through the course of treatment prescribed by her doctors, has brought Mary significant relief and allowed her to thrive. The issuance of the Paxton opinion and the Abbott letter, followed by DFPS's implementation of these to investigate the provision of medically necessary gender-affirming care as abuse, has wreaked havoc on the Doe family. The family is now terrified for Mary's health and well-being. And you might think this is one level of bad, but now it gets worse. Jane Doe works for DFPS. On February 23, 2022, following the issuance of that Greg Abbott letter, Jane communicated with her supervisor at DFPS to seek clarification of how the Abbott letter would affect DFPS policy. Such clarification was important for her family as well as her ability to perform her job at DFPS. That same day, just mere hours later, Jane Doe was placed on leave from her employment because she has a transgender daughter with a medical need for treatment of gender dysphoria. The next day, February 24th, Jane Doe was informed that her family would be investigated in accordance with Governor Abbott's letter to determine if Jane Doe and John Doe had committed abuse by affirming their transgender daughter's identity and obtaining the medically necessary health care that she needs. February 25th, DFPS Child Protective Services visited the Doe's family home to interview them. The CPS investigator interviewed Jane and John, who were accompanied by counsel, together while he interviewed Mary Doe, who was accompanied by separate counsel, which is what you do. It's normal for the child to have their own attorney in case the parents are abusive. You don't want the parents to have control over the child's testimony. Aside from interviewing the Doe family, the CPS investigator sought access through releases to Mary Doe's medical records, which the Doe plaintiffs refused to sign. The CPS investigator disclosed that the sole allegation against the family is that they have a transgender daughter and that their daughter may have been provided with medically necessary gender-affirming health care and is currently transitioning from male to female. The issuance of the Paxton opinion and Abbott letter has terrorized the Doe family and inflicted ongoing and irreparable harm. As a result, Jane Doe has been placed on leave from her employment. Should DFPS incorrectly find that Jane and John Doe have committed abuse, Jane Doe could face termination, which would result not only in the loss of income for the family, but also their health care coverage. Should DFPS incorrectly issue a finding that there is reason to believe they've committed abuse, they would automatically be placed on a child abuse registry and be improperly subject to all the effects that flow from such a placement. The letter has caused significant stress, anxiety, and fear. Mary has been traumatized by the prospect that she could be separated from her parents, lose access to the medical treatment that has enabled her to thrive. The stress has already taken a noticeable toll on her, and her parents have observed how their daughter, who is typically joyful and happy, is now moody, stressed, and overwhelmed. Jane and John are now filled with anxiety and worry. Ironically, while Abbott, in name only, says that this is child abuse, that action has now resulted in actual child abuse brought on by the governor. So, in a way, shouldn't it be Abbott that is charged with child abuse by doing this to innocent children? Jane has been unable to sleep, worrying about what they can do and how they can keep their family intact and their daughter safe and healthy. The family is living in constant fear about what will happen to them due to the actions by DFPS, the governor, and the attorney general. The family also worries about the potential physical and mental health consequences of depriving Mary of the medical treatment her doctors have prescribed and that she needs. Not providing Mary with medically necessary health care that she needs is not an option for them, as their topmost goal and duty are to ensure Mary's health and well-being. And that doesn't even mention the need for consistency with pharmaceuticals. If Mary is receiving puberty-delaying drugs, and then those drugs have to be stopped because of this investigation. And then even if the investigation determines that those drugs were appropriate, well, they've already done the damage. It's pretty terrible. So skipping ahead then, there is some good news already. This lawsuit was brought by the ACLU and Lambda Legal and the ACLU of Texas. And the judge in Travis County has already ruled as of March 2nd, granting the plaintiff's application for a temporary restraining order. From the facts set forth in plaintiff's petition and the declarations attached thereto, the court finds that plaintiffs will suffer irreparable injury unless defendants are immediately restrained from enforcing the governor's letter and the DFPS statement, both issued February 22nd, 2022, and which make reference to and incorporate Attorney General Paxton's opinion KP 0401. The court finds that Jane Doe has been placed on administrative leave at work and is at risk of losing her job, and that Jane, John, and Mary Doe face the imminent and ongoing deprivation of their constitutional rights, the potential loss of necessary medical care, and the stigma attached to being the subject of an unfounded child abuse investigation. The court further finds that if placed on the child abuse registry, Jane Doe could lose the ability to practice her profession, and both Jane and John Doe could lose their ability to work with minors and volunteer in their community. The court further finds that Plaintiff Mooney could face civil suit by patients for failing to treat them in accordance with professional standards and loss of licensing for failing to follow her professional ethics if she complies with defendants' orders and actions. If she does not comply with defendants' orders, Dr. Mooney could face immediate criminal prosecution as set forth in the governor's letter. The court finds defendants' wrongful actions cannot be remedied by any award of damages or other adequate remedy at law. It is therefore ordered that defendants are immediately enjoined and restrained from taking any actions against plaintiffs based solely on the governor's letter and DFPS statement, both issued February 22nd, as well as Attorney General Paxton's opinion KP 0401. It is further ordered that defendants are enjoined from taking any employment action or investigating reports against these plaintiffs based solely on facilitating or providing gender-affirming care to transgender minors based on the fact that the minors are transgender, gender transitioning, or receiving or being prescribed gender-affirming medical treatment. It is further ordered that plaintiff's application be heard before the Honorable Judge Amy Clark Meekum of the 201st Judicial District Court of Travis County on March 11th at 10 a.m. The purpose of the hearing is to determine why a temporary injunction should not be issued as requested by plaintiffs. The way this works, the temporary restraining order is very temporary, so March 11th is within 14 days of March 2nd, so that's appropriate. The temporary injunction or preliminary injunction is for the pendency of litigation, for the duration of the litigation, and then once there is a judgment or a decision made by the court, a permanent injunction will issue if appropriate. The clerk of court is hereby directed to issue a show cause notice to defendants to appear at the temporary injunction hearing. At issue for the temporary injunction hearing will be the validity of and enforcement of the governor's letter and DFPS statement, as well as Attorney General Paxton's opinion, and whether they violate the constitutional rights of the plaintiffs and other persons, the Texas Administrative Procedure Act, Texas law, or other applicable law. The current temporary restraining order just applies to the John and Jane Doe family and Mary Doe and Dr. Megan Mooney. It does not apply to everyone in Texas. The temporary injunction may apply to everyone in Texas. We will have to see. The temporary injunction hearing will decide whether a statewide temporary injunction should be issued to enjoin defendants from the following. 1. From investigating reports of any persons facilitating or providing gender-affirming care to transgender minors solely based on the fact that the minors are transgender, gender transitioning, or receiving or being prescribed gender-affirming medical treatment. That language would be used solely because there could also be child abuse. It is possible for someone to be transitioning, but also be the victim of other child abuse. The transitioning nature is not the child abuse, is what the court is trying to focus on here. From 2, prosecuting or referring for prosecution such reports, and from 3, imposing reporting requirements on persons who are aware of others who facilitate or provide gender-affirming care to transgender minors solely based on the fact that minors are transgender, etc. And that was March 2nd in Travis County, and that's Judge Amy Clark Meekum, or Meacham, which is, to me, quite obviously the right decision. The government should really have no basis. They really should have no hand in deciding what is medically necessary and what's not medically necessary. If the government wanted to legislate, the government should be doing that through legislation, and that legislation should be based on what doctors universally consider to be appropriate medical treatment. Having a governor issue a letter, which apparently is not even an executive order, but having a governor issue a letter and the Department of Family Protective Services and Child Protective Services to treat transgender issues as abuse is unbelievable. On one hand, I can believe it, coming out of Texas, the same state that put a $10,000 bounty on anyone receiving what should be a legal or lawful abortion. But it's still another level of inhumanity to see a child who is obviously having issues with their gender identity and say that to help that child is abuse. It is a level of evil that even I did not expect from Greg Abbott and Ken Paxton and the Department of Family Protective Services in Texas. So I'm horrified by this. You should be horrified by this as well. I don't know what we can do about it other than support the ACLU, support Lambda Legal, support the ACLU of Texas in their efforts to stop this evil and inhumane behavior. Let me know what you think in the comments below. Sorry, I need a minute. It's just terrible. So I'm sorry that we're ending on that note, but that is terrible. I think of my struggles as a child and how long it took for me to get help with my issues, which are not gender issues. I've definitely had some issues with my sexual orientation. My family was very accepting of people who were LGBT or gay, and my journey has been to accept that I am bisexual. It has taken a very long time. I am a monogamous bisexual, and I know that sometimes there's questions about how can you be married to a woman but consider yourself bisexual. It's because those things are not exclusive. I am attracted to both men and women. I am married to my wife, and I am faithful and monogamous to my wife. But I am also comfortable now with saying that I am bisexual. But for a very long time, I had trouble with that. And I looked at pretty much the same behavior that you see from people who struggle with their orientation. Sometimes you lash out at it. Now, I have not ever had a problem with other people being gay, but I definitely had a conflict in myself trying to come to terms with the fact that I was not straight. And I think back to those issues and other issues that I had in my childhood that went untreated, and I suffered because of that lack of treatment. And as an adult now, I want to see children be able to confront all of their issues, whatever those issues are, with their doctors, with their psychologists, with their parents, with their friends and family, and with the public, to be able to confront their issues as quickly, efficiently, fairly, meaningfully as possible, so that those children can overcome those issues and thrive throughout their life without the anchor, without the weight and burden attached to them of those issues going untreated. And here we have the Texas governor and attorney general, the leaders of the people of the state of Texas, doing everything they can to undo and make worse those issues. Here they are saying, not only can you not get treatment for those things, but we're going to turn everyone against you, so that you have to not only suffer with the condition that you have, now you have to suffer the stigma and the efforts against you. Not only do you have a health condition that needs to be addressed, we're going to tell you that you are wrong, that you are less, that you are abused or abusive because you're trying to address a sincere and genuine medical issue. It is disgusting, it is evil, it is inhumane, and it should be universally condemned. Acceptance and support is the most important ingredient to living a happy and fulfilled life. I agree.